Welcome, and thank you all for holding. I'd like to inform parties that your lines have been placed on a listen-only mode until the question and answer portion. Today's conference is also being recorded. If anyone has any objections, you may disconnect. If anyone needs operator assistance, please press star then 0. And I'll now turn the call over to Janice Wingo, International Trade Administration. You may begin.
Thank you, and welcome to this afternoon's webinar on the semiconductor industry in China. Today we are very lucky to have a Chinese attorney, Alex Zhang, who is a partner with the firm of Ting & Wood. He is a partner at their Palo Alto office. Mr. Zhang is a patent attorney, and he also has his LLM degree from the Beijing Technology and Business University. He has an MS degree from Beijing Technology and Business University, and his LLM is from Santa Clara Law School. He also was a visiting scholar at Stanford Law School and practiced with a firm in Germany as well. Today he's going to talk about various issues that affect the semiconductor industry in China. Afterwards, Mr. Zhang said he would be happy to receive questions from you. So the operator will tell you how to you can ask a question after Mr. Zhang's presentation. Alex?
Okay. Thank you very much for your kind introduction, Janice. I also want to thank everybody for making a time to participate in the webinar. So for today's presentation, I will focus on 4 aspects. So I will just give a very brief introduction about the growth of the semiconductor industry in China. I also want to cover, in the second part, I want to cover the IP protection for the semiconductor, what the IP right exists in China. For the third part, I will give some latest IP development in China, including the national strategy and the latest opinion issued by the China Supreme Court just 3 weeks ago. I think that will have a big impact to the IP enforcement in China. So in the last part, I will just recap all the presentation, give a summary about what's the effective, what's the practical IP strategy in China. So since the adoption of the policy of the reform and the opening up to the outside in 1978, China has adopted many good policies to attract foreign direct investment. The semiconductor industry is one of the key industries that the government encouraged. Today, China continues to expand its footprint in the global semiconductor marketplace. China now is accounted for 41% of the global semiconductor consumption. Over 40% of the global semiconductor initial public offering, and it employs more than 25% of the total global semiconductor workforce. That's very big in China right now. The global semiconductor industry has seen an acceleration of the structural adjustment. From this slide, you can see that China has gained a more important position in the global market and is attracting more attention from the multinational semiconductor companies. Many multinational companies have set up factories and increased their investment in China in an effort to gain a favorable position in market competition. To adapt to the special situation of the economic growth in China and win the fierce market competition, many multinational semiconductor companies have agreed to implement localization strategy in the field of the manufacturing, branding, human resource, marketing management, capital operation, and technology R&D. Such timely and flexible strategy have become one of the important reasons for multinational semiconductor companies' success in China. Homegrown semiconductor companies are also growing very fast, such as the Semiconductor Manufacturing International Corporation, Huajian Electronic Group, and others that compete directly with multinational semiconductor company and local company as well. So from this chart, you can see here the most heavy invest company in China, including Intel, Samsung, Toshiba, from U.S., from Japan, and from South Korea. So China's semiconductor industry total employee account has grown by around 10% during the last 5 years to about 300,000. This represents more than 25% of equivalent worldwide semiconductor employee. By comparison, if you compare that with the U.S. semiconductor employee count has decreased by about 4% annual rate. So China growing around 10%, U.S. decreased 4%. That's still exists today in China, in both sides. China also has emerged as a significant source of a new company and more recently of financial funding of semiconductor startup. During the last 4 quarters, as the semiconductor industry recovered from the global recession, Chinese companies have accounted for more than half of the semiconductor IPOs completed worldwide, 0.5% globally. Moreover, the Chinese financial markets have provided more than 80% of all the semiconductor IPO funding raised. China's share of worldwide semiconductor patents have been increased over the last 5 years, and an increased number are being, talk about the first issued patent in China. So if the semiconductor industry company, typically they, based on the WSC, semiconductor company typically spend 50% or more of the revenue on research and development, making IPR protection of all most important. According to the WSC, the World Semiconductor Council, semiconductor produce invest a very high percent of the revenue in R&D and the intellectual property that result in the lifeblood of this company. Failure to protect IP is damaging to the semiconductor industry and ultimately impede the semiconductor progress that has benefited consumers around the world. So China is part of the international agreement to protect the intellectual property, including the WIPO, the Berne Convention, the Paris Convention, and others. A company must register the patent and trademark with the appropriate Chinese agents and authority for those rights to be enforceable in China. Copyright do not need to be registered, but registration may be helpful in the enforcement action. A brief overview of the key patent, the layout, the trade secret, and trademark strategy will be explained in the below slide. So in China, talking about IP, there are 4 different types of intellectual property right in China, including patent, that protect that have 3 different kinds of patents: the invention, the utility model, and design. That give protection to the structure, the new technology, the drugs. So in China also, including trademark that protect the branding, the mark, the logo, the slogan, the copyright, and trade secret. Trade secret normally that can give you, protection for the secret with the economic value, which is not public. But But for the semiconductor industry, China also provides protection for its layout design. That's the semiconductor layout design. If you go to apply to before the patent office the cycle, the state intellectual property, you can also get a semiconductor layout registration and get protected in China. So, if you want to protect your semiconductor patents, I think there are two main considerations for both protecting your patent and avoiding infringing on others. The first one, a system of intellectual property right protection must be set up. That's very important. A corporation with its own patents can stop infringement with the protection coverage to maintain its market share, to snatch actual market share of the revival by litigation. Moreover, when an enterprise is charged with a patent infringement by a third party, it can evade or nullify the accusation by seeking and making use of the loopholes in the art's right. However, if the enterprise owns patents on its products, it can also use patent cross-license agreement as a bargaining chip to reach a settlement. Hence, for a high-tech enterprise, the possession of well-established intellectual property system can give a lot of leeway in deciding whether or to move forward or step back. If, however, the enterprise does not have its own patent, it will be in a dilemma, and find it's very hard to take its place in a fierce market competition. High-tech enterprise need to pay special attention to the patent application and the patent strategy implementation. To obtain the patent, the enterprise should be flexible and take various measures based on the local condition. They can research and develop technology on their own or apply for patent. They can buy technology, buy patent, file patent, make improvement on them and file patent application. Other options, including the technology, cooperation, the merge, the capital risk construction, you name it, I feel. Enterprise should also file patent application, in both sides, within U.S. and in China. If you have a big market, you should file a lot of patent over there. Just make sure you have to get the granted patent. For the U.S. semiconductor company, in China, you have both international competitors. You also have the local competitor in the market. We should always bear in mind in that you have a lot of competitors in China market. China make a certain Secondly, early warning system for patents is urgently needed. As the name implied, a patent early warning system is a mechanism that warning enterprise in advance for potential patent risks through the collection, analysis of the patent and non-patent information, so the enterprise can make precaution on their own initiative. When enterprise know both their opponents and themselves, they can take the initiative to escape the competitor's patent barrier and take necessary preparation measure in protecting their own patent. The patent early warning system make a patent application more targeted, raise their validity, and avoid the occurrence of the blind, invalid, or unstable patent right. Such a warning system enable a company's IP right protection to become truly rigorous, stable, and efficient. So China make a a third amendment to its patent law on October 1st, 2009. Several aspects have profound impact to any business in China, including the semiconductor industry, such as based on new law that adopted the so-called absolute novelty standard, the requirement, you need to obtain a foreign file license. You can also use the double patenting strategy, and the inventor compensation requirements is also very important. Here, I want to spend a little bit of time to emphasize the inventor compensation requirement. So, in according with the new law, for a service invention, the employer is required to give an inventor to a patent award after the patent is granted. After the exploration of the patent, the employer must also provide remuneration to the inventor. This provision applies to all entities in China, including the joint venture, the wholly-owned foreign enterprise. Without an agreement between the employer and the employee, or a corporate policy on the amount of patent award and the remuneration, that based on the law, the employer must pay no less than $500 for the invention patent as a patent award, no less than 2% of the profit earned from the exploration of the invention. This is very, very big. So the patent award should be fine at $500, but for the remuneration, if you do not have a contract with them, if you do not have a core policy, you need to give them no less than 2%. That gives a potential risk to any business operating in China. So in order to avoid the potential risk, I highly recommend any employer, if you have operation in China, you should have prepared a specific patent award and a remuneration agreement, or you have to set up a portfolio corporate policy regarding to how you want to encourage them, how you want to give them some patent award and some remuneration. So the revised patent law in China, that's in October 1st, 2009, has strengthened the patent protection by increasing the infringement cost, granting patent right on promotes for the sale to the patentee for the industrial design, empowering patent administrative authority, certain right to investigate and read patent right, and establish an evidence preservation system, like the trademark system, which will be discussed later. As shown by the table, you can see here that a phenomenal growth in the patent filing activity in China within the last decade. The annual growth from 1995 to 2010 is about 2%. That's a phenomenal growth. So for every industry in China, including the semiconductor industry, a solid patent filing strategy in China you should have to be considered in China. Because in China, as we know, no filing, no protection. If you do not file in China, you cannot protect in China. That's very, very basic. Also, if you look into some numbers, some statistics, the Chinese and other competitor, the local competitor, they're filing a lot of patents. They're trying to use the patent as a business to compete with others, to make, to compete in the market. So for any international company, for any U.S. company, if you want to success there, you have to think about your local competitor and the multinational competitor in that market. Just think about the patent have 20 years, a lot of time. Still, I hear a lot of complaint, still that, that don't have that many trust on China patent system. Just think about the 20 years from today. 20 years, everything will change a lot. So we have to think about in advance, planning in advance. So have a solid patent portfolio. You're covering the key technology, the main products, whether you manufacture in China, whether you sell in China. So you have to think about where is your market, where you want to protect them. So my recommendation is that a more aggressive patent filing strategy, you have to be part of the huge IP strategy in your company. So we need to have a filing strategy. We also need to have a very proactive patent protection strategy in China. So you may want to license all your part of your patent portfolio to others. You have that portfolio. You want to use your portfolio as a sword, trying to stop others to using your IP. You can use the administrative authority channel. You can also use the court, trying to prevent others to using your IP. You can assert against others. You can also use the patent portfolio as an asset. If you want to build up a JV, you want to have a business partner over there, you want to use that as an asset. So as we know, we can use the patent defensively as a shield, prevent third party from bring lawsuit. We can counter them against others. We can use that as a bargain chip against anybody in that market. So, just as I mentioned, in China, besides the patent can provide protection for the semiconductor industry, we can also use the semiconductor layout. Semiconductor layout, provide a unique legal right that are particularly useful in certain circumstances. The form of the protection is specifically included in the agreement on the trade-related aspect of intellectual property rights, the TRIPS, as a separate category. China adopted the protection regulation of the integrated circuit layout design to protect semiconductor mass work in 2001. Based on some information from the U.S. Information Technology Office, at this point, there have not been any serious layout design violation cases since its inception. In China, measure for the protection of the integrated circuit layout design focus specifically on the protection of the design of the semiconductor chips layout or the mass work. To qualify for protection, which extend from 10 years from the date of the registration of the first commercial use, this design must be registered within 2 years of the first commercial use. The form of in China, measure for the protection of the integrated circuit layout design focus specifically on the protection of the chip layout, just as I mentioned. They have 10 years protection from the registration of first commercial use. So while the protection of fraud mass work do not prevent independent creation of identical layout, the right holder does enjoy the following exclusive right. For example, the right to reproduce the layout design and the protection in its entirety or create part thereof, the right to exploit commercially the layout design, integrated circuit in which the layout design is incorporated, or an article incorporating such an integrated circuit. The exclusive right of the layout design belongs to the creator based on the law. So where a layout design is created according to the will or under the charge of the legal person or other organization, which shall bear responsibility of such layout design, that the legal person or other organization shall be the creator. So where the layout design is created jointly by two or more natural person, the legal person, or other organization, the ownership of the exclusive right shall be agreed upon by the joint creator. In the absence of such agreement, or where the agreement is not clear, the exclusive right shall be owned jointly by the creator. So where a layout design is created in execution of the commission, the ownership of the exclusive right shall be agreed upon by the person having the mission and the person being commissioned. If no agreement based on the law, if no agreement or it's unclear, the exclusive right shall be owned by the person being commissioned. The exclusive right of layout design established after the registration of the, with the SIPO. You need to register them before the SIPO. So layout designs that are not registered do not enjoy the protection under the regulation. So based on some number of the SIPO, at present, the majority of the semiconductor layout designers are local Chinese companies. That means that the international companies are not fully use this type of intellectual property right. So I would recommend everybody, if you want to protect your layout through the layout registration, that's a good tool. But I don't think that many companies use that tool as a very, very good tool for protecting IP. Besides the patent, the layout registration, China also provided the trade secret protection. You can see here, China has a myriad of statutes that protect the trade secret of confidential information that relate to the anti-unfair competition law, the contract law, the company law, the labor contract law. In one of the most famous cases between a Chinese semiconductor company and a Taiwanese company, the CMAC and TSMC, they settled this case for $200 million over the misappropriation of the trade secret. So from this case, I think they gave a from this case they gave a very good example. You have to take trade secret protection as part of your strategy. While the Chinese company law and other law, provide adequate statutory protection for the trade secret by allowing employer to impose confidential agreement on the employee or grant damage in case of the breach, the primary law on the top of the trade secret is anti-unfair competition law, which was promulgated on September 2nd, 1993. Under the anti-unfair competition law, a claim for trade secret misappropriation normally consists of two issues of analysis. First, are there any trade secrets that deserve a legal protection? The second, you also need to think about if the acquisition, use, or disclose of the trade secret prohibited and thus considered to be misappropriation. So Article 10 of the anti-monopoly competition law defines trade secret as the technical and business information which is not known to the public. The second, which has economic value and practical utility. And third, which the trade secret owner has take measure to maintain the confidentiality. Thus, the trade secret may include operation information such as the process, the method, the recipe, and other information such as the marketing strategy, customer list, material, term, price, so that meet all the above requirements. So misappropriation of the trade secret under Article 10, they including acquiring trade secret of another by theft, illegal by other illegal means, disclosing or using or allowing other to use trade secret or another acquired by the above illegal means, or disclose, using, or allowing other to use trade secret in breach of the agreement or confidentiality imposed by the legal owner. So in addition to these three forms of wrongdoer liability for trade secret misappropriation, Article 10 also defines third-party liability, where a third party acquire, use, or disclose trade secret that knew or should have known to have been misappropriated by any of the formation way. So to prevail in the trade secret misappropriation action, a trade secret owner must prove by admissible evidence in the challenge court that the asserted trade secret is not publicly known, the trade secret has economic benefit or practical utility, the trade secret owner has taken measures to protect the confidential information. The first one, there is a misappropriation of the asserted trade secret by the wrongdoer or a third party. So when conducting IP license or forming a joint venture in China, it's very essential to have a proper game plan to ensure that value trade secrets are not lost. In some circumstances, a joint venture is the must, entity. You have to be in China. So license trade secret to a JV is somewhat better than direct license to a Chinese company, because a JV can give trade secret owner more leverage to enforce right if the JV is properly set up. So in the license agreement and the JV formation agreement, we should specify that all decisions related to the intellectual property matter are to be decided by the majority vote, not a unanimous vote on the board of the director. We should also try and avoid using the term technology transfer. I would recommend using the technology license. In the license agreement, we should specify the license to use the trade secret terminate upon the termination or expire of the license agreement. That's either a right or continued use or a right to market or sell products made by or from a trade secret, and that the JV must return all the technical information to licensor. So in a JV formation agreement and a license agreement, we need to specify the licensor company should have the audit right of the termination of the agreement to ensure that no misappropriation of the trade secret occur, and provide the injunction relief. Is also a great remedy for the misappropriation of the trade secret. So for the competition agreement and the non-competition agreement, we need to have each person which have knowledge or access to the trade secret sign a confidential agreement and a non-compete agreement. If possible, execute the above agreement by all three parties, the licensor company, the licensee, partner, and the employee. when a third party, such as a contractor or consultant, is involved, we should require the third party to sign a confidentiality agreement and non-compete agreement. What's the preventive measure? So important trade secrets should be accessed by a limited number of people on a need-to-know basis. We should maintain a list of people who have knowledge or access to trade secrets. Moreover, a written confirmation of the knowledge or access to the trade secret should be obtained from each such person. If a third party will have access to confidential information, a written acknowledgement must be obtained in advance. That's also very important. Besides the pattern, the layout, trade secret, China also provide a trademark protection to any industry, including the semiconductor. So there are two principal pieces of legislation following the trademark system. That's trademark law and unfair competition law. The Chinese trademark law, they adopted the so-called first to file policy. The first file trademark enjoy the full protection by the law and may prevent late file trademark from registration and use in China. This is very, very different from the first use policy adopted in the common law system that in the U.S. Please bear in mind, only registered trademarks are protectable in China. One mark in one class is considered as one application. So most class applications are not acceptable. Separate applications are required for additional application. China, they provide protection for the trademark on the word, the device, the letter, the number, three-dimensional shape, and the color combination, and the combination of all the above elements. As they say, still the sound mark, the scent mark, and the moving mark are not acceptable. So the unfair competition law prohibits the misappropriation of the trade secret and provides holder of well-known marks anti-dilution protection, like the protection of loss of goodwill. Trademark owners should not underestimate the benefit of registration procedure in China. Indeed, as opposed to the first-to-use principle that is applied in the United States for registering a mark, the Chinese trademark law follow the first-to-file principle. We need first-file. For the semiconductor industry, we also need to file them with the state trademark office. So the trademark office accepts the application directly from the individual or the legal entity. So they have a very specific procedure. If you are a foreign entity, if you do not have a direct presence in China, you should use an agent to apply for registration. So once the application is received with the payment of fee, it must pass the preliminary approval examination. Once it passes that examination, the application is published. So they also have a procedure is called opposition, so they can the publish over there. Any public can provide the opposition to oppose the trademark. If no opposition, the mark will be proceed to registration, and the certificate of trademark registration will be issued. In the case of rejection, the applicant has 15 days to appeal to the Trademark Review and Injunction Board. Okay. So I want to spend 2 minutes talk about this case. This is between the U.S. company filed and the Chinese company regarding the Chinese mark. Further, they sell Viagra in U.S. also in China. In China normally they use very the term a very good term to call the Viagra. They call the Viagra as a Uyghur. So in 1998, the Chinese company that filed Chinese mark Uyghur with the China Trademark Office. 2002, filed opposed the mark Uyghur. That means much broader, and it was denied by the Trademark Office. Then in 2005, filed trying to sue Wellman before the Beijing #1 Intermediate Court, claiming the ownership of the mark of the Uyghur, and got denied. So this is a very good example about the first filing system in China. Even the people know that mark belongs to Pfizer, but since Pfizer do not register the Chinese mark in China, based on the first filing system, the Chinese company Wellman have the right to get the trademark. So in 2007, even filed appeal to this case to the Beijing High Court, and finally they get rejected. This is an example. We should planning first and file the corresponding the Chinese mark in advance. So we also need to think about the procedure, think about the case. For every company in China, they need a good trademark consideration, some strategy in China. We should bear in mind that China is the first to file rule. You do not need any evidence of the prior use or ownership. So whenever you want to launch your product, not only think about your U.S. market, you also need to think international market. You should register your market well before launching your products in China. Chinese language version of the trademark is also necessary. Most of the people in China still today, they call it's very easy for them to remember the Chinese correspond. It's not that easy for them to remember the U.S. word. So I highly recommend whenever you have a mark, you should adopt not only the Chinese version, in English version, you also should adopt the Chinese version. Also, you want to reasonably extend your coverage of the good or service to the related one. You want to have a more broad coverage. You don't be too narrow. So you also need to monitor your market routinely. So whether somebody use your mark or some trying to dilute your mark, you have to build that in your system. Before I just cover full aspect of the IP protection for the semiconductor industry, that cover the patent, that cover the layout, the trade secret, and the trademark. So I also want to spend a couple of minutes to give you some new information about the China national strategy and some later development. So in 2006, China, the National Medium and Long-Term Plan for Science and Technology Development was published by the State Council. In this plan, the central government created a clear vision to foster innovation in China in the future by promoting the science and technology development in selected key fields and enhance innovation policy. They want to, by 2020, it's predicted that the R&D investment of the nation will be more than 2.5% of the total GDP. The plan also projects that by 2020, China will become innovative nation That plan further recommended that adoption of several important policies and measurement, including encouraging indigenous innovation and implementing national intellectual strategy. In 2010, CIPO also published the National Patent Development Strategy. They have a very, very bold goal. So by 2015, the annual patent filing in China will reach 2 million. If that achieved, China will rank among the top 2 in the world in terms of the annual number of the patents for invention granted to the domestic applicant. That strategy projects the number of the overseas patent applications filed by the Chinese applicant will double. If you look into the article published in January 1st, 2011, in New York Times, that also have an article that title is called "When Innovation Too is Made," it also is made in China. So that means China, any company, whenever you design your strategy, you should think about the China national strategy. You have to think about that strategy and build that strategy in part of your strategy. Because China right now they're trying to build up an economy that are heavily reliant on innovation rather than manufacturing imitation. It's very interesting. So 3 weeks ago, on December 16, 2011, the Supreme Court published a very lengthy policy. It's called Opinions Regarding Several Issues Related to the Sufficiently Used IP Adjunction Rules to Promote Vigorous Development and Prosperity of Socialist Culture and Motivation Autonomous and Coordinated Development Economy. From this opinion, you can see it's apparently that they want to intend to support the latest CPC policy agenda in trying to encourage innovation and to improve the judiciary protection of the intellectual property right in China. The opinion has come up with a number of the policies, the principle, the rules with respect to the patent, the copyright, the trade secret. All these rules are expected to have immediately effect on the way how the court try to handle IP cases in China. It will help for the court to adopt the same trial standard throughout the country and create a better legal environment in China. Several aspects of the opinion will have profound impact on IP trial in China. For example, for the patent protection, Section 13 of the opinion suggests that when determining the specific patent protection scope, the judge should appropriately consider the patent right, particularity of different technology area and innovation reality. For the first created innovation, which involve high degree innovation, giant investment, having breakthrough and driving effect of economic growth, the court should provide broad and high strength of protection. That means for the very big invention or the high first created invention, the court recommend you provide the broad and high strength protection. But for improving invention which involve low level innovation, the court should limit its protection scope and the doctrine equivalent. That means they trying to give more protection to the first created, the high degree innovation. I think this is a very, very big change. So, for example, in China, they have three kind of a pattern in China. They have a utility model, they have invention, and have design. So, based on this opinion, they will provide more protection to the invention pattern and give less protection to utility model. That's a very, very encouraging sign because a lot of people complain about the junction pattern in China. I think that's very, very clean sign. Also, in the section 15 of the opinion, that relate to the issue of the burden of the proof, evidence discovery, and infringement determination relate to the process patent and the method patent. The process made by the opinion, the progress made by the opinion could be very meaningful to protect process patent in China. As you may know, in China, they have no evidence discovery tools. It has always been very challenging to patent litigator to prove infringement or method claim or process patents in the court, unless the court can, grant a broad order of evidence preservation. The plaintiff often have very few to empower that process. What process has really been used by the defendant? To solve that problem, the Chinese court have adopted the so-called reverse burden of proof, and which the defendant bears the burden to prove what process it has been using, if the accused product qualify as a new product. Here, only new product that have the reverse burden of the proof. However, the adoption of the reverse burden of proof not only fails to address the problem, but also lead to new dispute. What's the new product? For those patent claims that relate to the existing product, you even don't have reverse burden of proof. You cannot take that advantage. So Section 15 of the opinion make a new effort to solve this problem. The Supreme Court emphasized that the lower court should not only apply the principle of shifting the burden of the proof mechanically in hearing process patent. To do this, the Supreme Court asked the lower court to take into account two primary factors. The first one, whether they have any practical difficulty for a patentee to protecting the patent right. The second one, the legitimate interest of the accused infringer for protecting the trade secret. According to Section 15 of the opinion, the court states that while the product manufactured by process patent is not new, and the patentee is difficult to acquire evidence of the accused manufacturing process, if the patentee can provide the following two facts: the defendant indeed manufacture the same products, and there is great possibility of the accused infringer to use the patent process based on the circumstance, the known facts and data experience. If you can present the two facts, so the court will grant the reverse of burden of proof. So when the plaintiff succeeds in proving the two facts, the burden of the proof will be reversed to the defendant. In other words, the defendant now has to bear the burden to prove that the manufacture process is different from the patent process. So, based on the opinion that the Supreme Court also suggested the lower court should be more active in turn out evidence preservation measure and further reducing the patentee's burden of proof. The court stated in the opinion that the actual manufacture process is often part of the defendant's trade secret. They also ask the court trying to protect the trade secret of the defendant. They at one side they encourage the court to use the reverse burden of proof. In other side they also ask the lower court, you have to very care about the trade secret of the defendant. You have to avoid the abuse of the evidence preservation measure and the illegal leakage of the trade secret. The Supreme Court asked the lower court must take a proper measure to prevent the illegal disclosure of the defendant's trade secret. So this opinion, from what I'm described here, this opinion they also cover a lot of trial practice in China related to the patent, trademark, trade secret, and copyright. Since the time is very limited, I think this opinion will have a big impact, will have, change the trial practice in China in the very, very future. So from what I'm talking about here, I want to recap the IP protection strategy in China. So first, we need to prepare. So if you budget enough, you have enough budget, you should protect and enforce your IP right. You also need to raise the awareness of the potential of the infringement of your semiconductor IP. So you also need to do due diligence. Do a due diligence research of your potential business, your partner. Were they in any way involved in intellectual property infringement before you want to demand that potential business partner sign a confidentiality agreement before you hand over any sensitive business information? That's essential for the trade secret protection. You also need, register your intellectual property right. Register your patent, your layout design, your trademark in China. No design, no protection. So you also want monitor and do some research. You need to monitor the use of your intellectual property right in the plant frequently. Know who has access to your plant and to your intellectual property right. Use and combine several anti-counterfeiting technology. Monitor whether intellectual infringement in your market, if they are counterfeit product, track the original and gather the evidence. So you also need, proactively trying to enforce your patent, your IP, your trademark, for example, you can use the SIPO as the SIPO and the local patent office as a tools trying to administratively enforcing your patents, your utility model and your design. You can also use the administration of the industrial commerce AIC trying to enforce your trademark. AIC have very, very big power in China. That's very quick and very efficient. For any trademark infringement, that's good too. You should bear in your mind. So you can also register your patent copyright with the National Copyright Registration Center. So the advantage of the administrative enforcement is that it's very easy, also very cost efficient. The disadvantage is that there are no damage award and the punishment is very, very limited. They only can, confiscation to infringe good or the fine. So besides the administrative authority, you should think about the civil procedure enforcement. You also can think about your criminal enforcement road. In civil enforcement road, for the patent, I highly recommend you go to the court. You get the injunction. You get the damage. Even today, even the damage is not that high compared with the U.S. I think that's still very good rule. But just as I mentioned, based on the opinion issued by the Chinese Supreme Court, so that will definitely change the civil enforcement situation. I think I would expect the damage in the future will be more higher and higher. So the last one, the criminal enforcement is also very good too. China court employ a different discovery system. A lot will be expected from the criminal enforcement road in China. Because of the alleged deterrent effect, they have a lot of advantage. But for the criminal enforcement, they also need a very, very high threat of the evidence requirement. That's something you need to put in your system. So that's pretty much my presentation of today's presentation. So if you have any questions, so you can write an email to me or, you can forward to me. So, Janice?
Hi, thank you, Alex. Operator, can you let the listeners know how they can ask any questions of Alex?
Yes, thank you. If you would like to ask a question at this time, please press star 1 on your touch-tone phone. To withdraw the request, you may press star 2. Once again, star 1 at this time on your phone if you do have a question, and it does take just a moment.
Alex, while we're waiting for the questions, can you give your advice to companies regarding filing for both a utility model and an invention patent in China?
Yeah, yes, that's some new thing in China based on the new law. So in China, you can file a utility model and an invention at the same time. Because they have a different protection scope, so for the invention application, they can cover the structure, the shape, the process, and the method. But for the utility model, they only can cover the structure system. For example, if you have very important products you want to launch in China as soon as possible, that's the good rule. You can file them both on the same day and indicate in the filing form. So normally within 1 year, the utility model can be get granted. So before the invention get granted, you write, submit a document and indicate to the patent office you also have a utility model. So you just can easily abandon the utility model and get your invention patent grant. This is a very, very useful rule whenever you want to, launch your product in China as soon as possible. Because normally invention patent normally take about 2 or 3 years get granted, but for the utility model, that can be get granted within 1 year. So that's the rule. Some Chinese companies they use that a lot. For the U.S. company, I think we also should bear in mind because there have no utility model exist in U.S. So you should speak with your Chinese local counsel whether it's an option, whether I should use that system to protect my IP in China. Yeah.
It's also a defensive strategy, isn't it, to prevent a Chinese company from fraudulently registering your invention patent as a utility model?
Yes, I agree with you. So some of the Chinese companies, when they saw something in a global market, then maybe the first file there, they file a utility model, then they can, kick you out. Before you file in China, you cannot get the patent. So if you file your utility model in China as soon as possible and get granted, I think you can, solve that problem. Somebody trying to, use your invention to get a patent to trying to sue you. I think that's both the defensive strategy also is it's very. We should think about that whenever we have a very important invention you want to protect in China.
Just can I ask you about how much more does it cost if you're going to file an invention patent? How much more does it cost, including translation fees, to file for the utility model as well?
So for the utility model and the invention, both of them you need to pay the translation fee. That's both for them. But if you file them at the same time, so I think the agent can only charge one translation fee because they have the same spec, almost the same claim. So the translation fee should the same, but the office action maybe for the utility model they have no substantive examination. They only have a preliminary examination. That cheap is very the price is very cheap. Normally maybe cost you less than $1,000 for the Q of the action. But for the invention, I think it's much higher because you need to get the of the action, you need to go back and forth and argue with the examiner. So if you file them both, you only need to spend one translation fee, and the prosecution of the utility model also very, very cheap. So I think that's a good strategy.
And I am showing no questions on the phone lines.
Okay.
Alex, since you used to work in Germany, I know that the Germans also have utility models that were also not examined. Can you explain? We hear many companies in China complain that someone has filed their invention patent as utility model in China. But when you talk to German patent attorneys, you don't hear of that situation. Can you explain why it happens in China and it does not happen in Germany?
I think maybe the main reason because utility model is so cheap in China. It's so cheap, people can find them very easily. Also, another reason maybe it's very easy to China. They have a lot of product manufacturing in China. Whenever there's some new products launched globally, they try to manufacture locally. Then they may check whether they have a patent or something. If they do not see any patent, they're trying to use the first filing system to get a patent and trying to market them products. And they're trying to use the patent as a leverage to sell the products. Also, they have no big penalty for you find a patent. For you find a patent. I think that's some reason. That's my personal opinion. Yeah.
We do have a question if you'd like to take that.
Yes, please. Yeah.
Ian Stepp, your line is open.
Yes, this is Ian Stepp with the Semiconductor Industry Association. Thanks very much for taking the time to brief the group today. My question relates to counterfeit semiconductors made through the remarking process that I'm sure you're probably familiar with. I'm wondering if you have any advice for semiconductor companies that have fallen victim to counterfeiters that are altering the trademark and/or information on the chip itself, and then marketing it as a different product. We have been working with the U.S. government as well as SAIC on this issue, but we're interested in your thoughts.
I have one recommendation. The first one, you have to monitor your chips, your product in China routinely. So whether you found some counterfeiting stuff in the website or some brochure, you have to monitor routinely. The second one, you have to use that system trying to enforce them proactively. Trying to use that system, use the court, use some investigator, use the administrative authority, trying to aggressively, proactively to enforce your right. For example, if you aggressively trying to promote, and I think the counterfeiter will, definitely will, cannot counterfeiting you. So I think that's some measure we should adopt in our strategy. Monitoring, work with the agents, government agents, work with the attorney, with the court system, trying to proactively enforce, protect yourself. Yeah, I think that's the only. Also, you should also work with some government agents trying to promote the intellectual property protection. Some industries have an association in China. You should work with them. Find some hearing from them, trying to work together, work with the international company, also work with the local company, work together, find the best approach. Yeah, that's something in my mind. Thank you.
Thanks.
Alex, would you also recommend recording your trademark registration with Chinese customs?
Yes. For some the manufacturer, there's some product that only manufactured in China, but sometimes they do not sell in China because they just manufacture in China, then they resell to other parts. For example, they maybe resell in U.S. In that situation, I highly recommend you record your trademark with the custom. Then whenever you have some evidence, some trace, you can go to the custom, ask them, give you protection. I found that's a very, very efficient method to protect your trademark and to handle with the counterfeiting stuff. Yeah. Yes.
There are no further questions on the phone lines.
While we wait for one last question, I wanted to remind the listeners that this Friday at 10:30 Eastern, there will be yet another webinar on the updates from 2011, China IP updates from 2011 at 10:30 this Friday. Also, anybody who's listening to the audio recording, Alex said he would be very happy to take questions from you. He's in Palo Alto, and his number is 650-858-1285, or you can reach him at alex.zhang@kingandwood.com.
Still no questions on the phone line.
Well, if there are no other questions, I'd like to thank the listeners and particularly thank Alex for this quite comprehensive presentation on IP issues for the semiconductor industry. And if you have any questions, again, Alex has been very generous, and he said he would be happy to receive emails or questions from the listeners. So again, thank you, Alex, and thank you for listening to today's International Trade Administration China IP webinar.
Thank you. Thank you for having me. Thank you very much.
Thank you. This does conclude the conference. You may disconnect at this time. Have a great day.